And for states, I wasn't sure if that came down. They sent that letter saying they wanted to reconcile. I sent it to Jen yesterday, but I haven't heard that it came down.
I don't have it on my docket.
Oh, okay. I haven't gotten confirmation.
Okay, Mr. Tomaso, I did see Mr. Engstrom connected. I don't know if he got booted off, but if you could just hold for a minute, I'm sure he's going to reconnect.
Of course, Your Honor.
Yeah. Can you hear me, John?
Yes, I can hear you, Angela.
Okay. I had to find the button. Hello.
Okay, Mr. Engstrom, are you able to hear me okay?
Yes, Your Honor.
Okay, great. So let's go on the record. This is Johnson versus Johnson, case number 2314334. And we have both counsel connected here by Zoom, and both parties are also present by Zoom. This is set for a status conference in this case today. On behalf of the plaintiff, Mr. Engstrom, can you kind of tell me where things are at from your side?
I think there's two issues well, there's probably three issues, Your Honor. The marital home, it's debt-free, and from looking at Mrs. Johnson's trial brief, she wants to take that and keep it, but I don't think she has a means of buying out Mr. Johnson's half interest in that. His half interest is approximately $130,000. There's a 401k that he collected, $60,000 of it he had before he got married, so she's entitled to the additional 60. It's worth 120, but 60 was premarital, so she's entitled to 30 on that one. And then she's asking for spousal support of $1,000 a month, which is a problem.
Okay. No. Okay, so I mean, from your standpoint, Mr. Engstrom, I know you guys did try mediation. Do we just need to set this for an evidentiary hearing and have the court decide on those issues? And I'm going to hear from Mr. Tomaso in a second, but from your standpoint.
I think so, unless he can tell you something that I don't know, how she can buy him out on the house.
All right, Mr. Tomaso.
Yeah, this time, Your Honor, I think just setting it for an evidentiary hearing would be appropriate, because I do think the issue of the spousal support is a major factor in her ability to purchase the home and continue. And I think once testimony is heard, there may be some things with regards to that, Your Honor, that would allow her to keep the home.
Okay. All right. Mr. Engstrom, from your standpoint, how much time do you think we would need for proofs in this case?
No more than a day.
1 day. Mr. Tomaso, would you agree?
As long, I would only need half a day, so I believe, I don't want to speak for Mr. Engstrom. I think he's in a day total, not a day for himself. I just want to confirm that.
That's correct.
Okay. Yeah, I would agree that a full day would be appropriate, Your Honor.
All right, and then both counsel, I mean, is there a particular period of time that you both need to be ready to go? I mean, do you want me to set this 90 days out, 60 days? How much time would you both need to be ready?
We could do it in 60 days, Your Honor.
I would agree 60. I just would let the court know I'm on vacation from like the 12th to the 24th of June. So there's about a 2-week period. Other than that, would be able to, Your Honor, after that. I guess that's only a month away, so 60 days would be past that period. Sorry about that. My math is not great.
Yeah, that's okay. Okay, so I'll set this for a 1-day bench trial, about 60 to 90 days out. I did see that you both submitted trial briefs, so I can just take those. I'll just ask that the two of you exchange witness and exhibit lists 14 days prior to the trial date. The trial will be in person, so I'll need all witnesses and counsel and the parties to be present here in Kalkaska for that bench trial. Mr. Engstrom, from a scheduling standpoint, anything else that I can address for your side today?
I'll be gone July 11th and 12th, so you're not scheduled for the 11th and 12th?
Hold on one second.
Judge, when do you usually hold trials on these cases? What day? Is there a certain day?
No, but I do have a particular week that I have as my trial week in Kalkaska. It's usually the second week of the month. Well, actually the third week of the month. So it's the week after my motion week. Yeah, so the third week of the month. So it's generally would be in that time frame.
I'm usually pretty open on Mondays and Wednesdays, Your Honor. If you can find a Monday and Wednesday, I'd appreciate it.
Okay, I'll note that for the record. And Mr. Tommaso, any other scheduling matters I could address for you today?
No, this time, Your Honor. Thank you.
Okay, so the court will send out notice of the date and time of that one-day bench trial. And we'll go from there. The court won't schedule any further hearings prior to that. So to the extent that either party has any motions, they would need to be filed and set for hearing, of course, prior to the bench trial date. And that's all for today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Ferrone, are you able to hear me okay?
I am, Your Honor.
All right. Do you know if your client is going to be present for this hearing today?
I don't believe so, Your Honor. We would waive his presence.
Okay, so we'll go on the record. This is People versus Daniel Lidster, case number 224731. If I could have both counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Good afternoon, Michael. Ferrone on behalf of Mr. Lidster.
Okay, we're set today. Mr. Ferrone, this is your motion for some to obtain some trial exhibits. I'm just zooming the camera out, Mr. Ferrone, so you can see Mr. Ziegler there. Mr. Ziegler, do the people have any taking position with regard to this request?
No, Your Honor. In fact, my office has been a little busy recently, but I seem to recall mailing a copy of the requested video to Mr. Ferrone's office. If he hasn't received it, I have no objection to mailing him another copy.
Okay, Mr. Ferrone?
I haven't received them yet. I don't know when they were mailed. I know the mail can take a while to reach its destination. No, I haven't received them yet.
You know when those were sent?
It was some time ago, Your Honor, and I may be misremembering. I did not make a note about mailing it, but, Mr. Ferone, are you just looking for the body camera video that was admitted as an exhibit?
Yeah, basically, all of the trial exhibits, because there's little doubt the Court of Appeals is going to ask me to produce them. That seems to be routine at this point. In the past, it wasn't. In recent years, they always ask for copies of the exhibits. They'll ask me for them, and so all of the video trial exhibits.
I have no objection to producing whatever's in my possession, Your Honor.
Okay, so Mr. Ferone, if you just want to prepare just a very brief order that reflects that we had the hearing and the prosecutor is not objecting to the relief and that the prosecutor is agreeing to provide that like within the next 14 days, Mr. Ziegler.
I can do that, Your Honor, yes.
Is next 14 days, is that sufficient, Mr. Ferone?
It is, Your Honor. Thank you. Thank you, Mr. Ziegler. Thank you.
Okay, that's all I have for today. And Mr. Ferone, you're free to disconnect at this time.
Thank you. Have a good day.
Thank you. Next meeting set for 2 o'clock, so we'll take a brief recess until then.
Really stupid question for you. Because it's almost 2 weeks on.
Okay, looks like we have council connected. We'll go on the record in Dan Woods Properties versus Dobson. This is case number 2013517. If I could just have council put your appearances on real quick.
Afternoon, Your Honor. For the record, Attorney Kyle Ream on behalf of the plaintiff, counter defendant.
Lance Zorhoff on behalf of the defendant and counter plaintiff. Well, yeah, defendant and counter plaintiff. I also noticed that on the notices from the court, Dennis Dobson, who's my client, and Double D Whitetails LLC are both listed as pro per. So I don't know how that. I just bring that up because I've seen that in the last few notices. Anyway.
Okay, I'll ask Jennifer to take a look at that. I'm not sure why that would be showing up that way. Obviously, it shouldn't be.
Yeah.
Okay, so we're on the record today. Looks like the last time that we met was back in February. Parties were going to look at participating in some mediation, and we set this as a control date about 90 days from then. So I guess, Mr. Ream, starting with you, what's your side of where things are at this point?
Well, Judge, we have a mediation / facilitation date tentatively June 24th or June 27th. So that's the date. We couldn't get it done in time in that 90-day period. I think Lance is going to tell you his client had some health issues, or his family did, and we didn't move as fast as we could have, and it's not really directly related to us. Judge, there's a little outside forces here, but we're trying to do our best.
Okay, thank you. Mr. Zuroff?
Yeah, that's right. My client's had some personal health issues and then some issues with his mom, which has prevented him from full attention to this. But we're still working towards getting it to mediation. I do think it would be productive to have these folks mediate and hopefully be able to see if they can't come to some kind of middle ground, but we'll see.
All right. So let's just have that mediation go forward in June, and then I'll set this for a status conference sometime subsequent to that, either in July or August, wherever I have a spot in the docket. And we can see where we're at that point. Do either of you have any objection to that?
No,
No.
Judge, that's very logical.
Okay.
Just so
Anything
you know,
else?
just so you know, Judge, Lance and I are in agreement on where this thing should go. So I'm optimistic with a third party assisting the two of us, we should be able to do something with this file.
Okay. All right, very good. Anything else I can address for either of you while we're on the record here today?
No, Judge.
No.
Okay, thank you. That's all for today. And I'll send out notice of the date and time of that next status conference. If for some reason it does resolve through mediation and we don't need that, if you just contact my office, I'd be happy to take that date down too, so that you don't have to appear for that.
Thank you, Judge.
That'd be great. Thank you.
Bye, Lance.
Okay.
Bye.
Afternoon, everyone.
How you doing?
Good afternoon.
Okay, we've got everybody connected, and so we'll go on the record now. This is Richardson versus Rose, case number 2414376. And let's see if we could start with plaintiff's counsel, Mr. Stern. Could you put your appearance on the record, please?
Yes, Judge. Nice to meet you. My name is Todd Stern. I'm proudly appearing on behalf of the plaintiff here.
Thank you. And then counsel for Miss Rose.
Good afternoon, Your Honor. Sean Kelly on behalf of defendant Jill Gail Rose.
Thank you. And then Chubb National Insurance.
Afternoon, Your Honor. Trevor Potter on behalf of defendant Chubb.
Thank you. And then finally, auto owners.
Good afternoon, Your Honor. Christy DeVos appearing on behalf of defendant auto owners.
All right, thank you. We're on the record here today for purposes of pretrial scheduling in this case. And so I'd just like to set some dates going forward. Typically, what I do for a first scheduling order is just set aside a period of discovery, a period to for the parties to engage in mediation, set a dispositive motion cutoff, and then set another status conference after that to kind of see where things are at. So Mr. Stern, going first on behalf of plaintiff, are there any particular timeframes that you would like to request for those issues?
Judge, this is a standard first and third party auto case. I think 120 days for discovery is probably plenty of time.
Okay, defense counsel, anybody have anything different than that?
Sounds good to me, Judge.
I think it's a good start, Your Honor.
Agree.
Okay, so we'll set aside 120 days for discovery. And then in terms of mediation, does anybody have an objection to having mediation within that time frame?
Your Honor, we find that if we're going to facilitate it, it's usually helpful to have completed discovery so that everybody kind of has all the medical records and knows all the issues. And so I would probably request that we do that shortly after discovery closes.
Okay, anybody have an objection to that?
Nope, I would agree.
Same.
All right, let's set mediation to occur, let's say mediation within 180 days. So mediation within 6 months, that'll give a little bit of wiggle room outside of that discovery period to get that set. And my pretrial order provides for the parties to attempt to agree on a mediator. So that would need to occur within the next 14 days. So I just need you all to confer and see if you can agree on the person to mediate within 14 days. And then if you can't, then there's a court selection process to pick a mediator. Does anybody think that's going to be an issue in terms of agreeing on a mediator?
We should be able to find somebody, Your Honor.
Okay. And the court does send out a list of the court's approved mediators with the pretrial order, to the extent that there isn't somebody that you guys already have in mind. And then I would like to set this for dispositive motion cutoff at that 180-day mark for dispositive motions to be filed. Does anybody have an objection to that?
No objection, Judge.
No, Your Honor.
All right, and then I'll set this again for another status conference at the close of that period to see where things are at. If it looks like mediation wasn't successful and isn't likely to be, we could talk about potential case evaluation at that point, and also look at getting it kind of on more of a trial track at that point as well. And I will send out notice of the date and time of that status conference. It'll be by Zoom like we're doing today. Are there any other dates, Mr. Stern, on behalf of the plaintiff that I can address that you would like to have in the pretrial order?
I don't think anything really comes to mind, Judge. Well, I guess witness lists, you have a witness list cutoff date of some kind?
I found that the parties typically through the process of discovery are, exchanging those kind of lists. Certainly if it looks like it's gonna be on a trial track, that would be some cutoffs that I would set at that next status conference going forward. But if you guys want to request some type of preliminary witness list disclosures, during discovery, I'd be happy to set those as dates as part of the order.
I mean, I think we all, if I remember correctly, have all submitted initial disclosures. So I think those have our initial witnesses at least.
Yeah, okay. All right. Mr. Potter, on behalf of your client, any other dates that you'd like to see in this order?
No, Your Honor, I would just ask, with respect to the choosing of a mediator, does the court want a notice filed or a simple email to the clerk? What's the court's preference?
Right, so the pretrial order, which I will send out a copy of this with these dates, indicates that the parties just need to notify the court in writing, whether that's, through regular mail or email, but just something written indicating their selection.
Sounds good. Thank you, Judge.
Mr. Kelly, on behalf of your client, anything further?
I'm all set, Judge. Thank you.
Ms. DeVos?
If I could just get a little bit of clarification on the court's witness list, policy, it basically just making sure that the witnesses are disclosed and during discovery is the court's requirement on the witnesses.
I'm sorry, you're kind of breaking up a little bit there. Can you say that again?
Yeah, sorry, I'll move a little closer to the mic. I just want to make sure I understood the court's procedures with respect to disclosure of witnesses, but basically the court just requires that the witnesses be disclosed during discovery.
Right. Yep.
Okay, thank you. I just want to make sure. Thank you.
Sure. Okay. All right. So as I said, I'll send out a copy of the order with the dates that we've discussed here today, along with the notice of hearing for that status conference around 180 days. And we'll go from there. All parties are free to disconnect. Thank you.
Thanks, Judge. Have a great day.
Thank you.
All right, it looks like we've got all council connected, so we'll go on the record in Nellis versus Munson Healthcare. This is case number 21-13787. And we have Mr. Elliott present on behalf of the plaintiff. We have Mr. Arteev present on behalf of the Kalkaska defendants, and Ms. Olson present on behalf of Munson. I do have somebody joining on the phone. Can you tell me who you are, please?
Yes, Your Honor. Good afternoon. Jim Elliott, also on behalf of the plaintiffs. Unfortunately, I'm not near a computer.
Okay, sounds good. Thank you. So we have all parties present, and we're set here for a status conference in this case to conduct some further scheduling. So I guess Mr. Elliott, whichever one of you wants to address on behalf of plaintiff, in terms of setting dates for going forward, do either of you have any suggestions for scheduling?
Well, we've already completed a number of depositions, Your Honor. 4 depositions. We have 3 more scheduled for next week over a 2-day period. We also have spoken about the possibility of a facilitation. We thought we would get a few more depths in first. And so that's really the status of what we've done. We're moving along on this. If we had time to do some additional depositions, there's always a possibility it could get resolved. So having said that, I don't know if you would consider giving us a short time to complete that aspect of it. If defense counsel are still on the same page with me, Ms. Olson wasn't involved in that conversation, but I assume it's been relayed to her. So that's a situation since we've talked to you last.
All right, thank you. Mr. Arteev or Ms. Olson, do either of you have any objection to, I mean, I guess what I'm thinking is if we were to build in like 90 or 120 days for the parties to finish up depositions and then have mediation, and then the court would set it for another status conference at the expiration of that period. Does that sound reasonable?
Yeah, I think that's kind of the path we're going down, Your Honor. I think we're continuing on with depositions. I think it kind of depends on how many, more depositions plaintiff's counsel intends on doing, and the availability. I assume if he does more depositions, they're going to be medical providers, so their schedules are always kind of hectic. But I think I'll defer to the court whether 90 days or 120 days is appropriate. And as Mr. Elliott indicated, we've already had discussions about potentially scheduling mediation. So I think that's the path we'd like to go on for now.
In Your Honor, Jim Elliott again. In reference to the timing, I think on our end, it would only take a few more depositions to proceed to facilitation or mediation at that point. And then if that doesn't work, possibly just a suggestion, have another status conference to schedule the final dates, cutoff dates, things such as that. But give the mediation option a good try first, I guess is my thought.
Okay, Ms. Olson, anything you wanted to add to that?
The only thing I would alert the court to, which is probably no surprise, we intend to pursue a motion. So if the other parties want to resolve it and, dismiss the matter and dismiss us, that's perfectly fine. I just don't, it doesn't sound like the court is setting any deadline for an MSD hearing or anything like that at this point.
No, I mean, I would wait until after the parties had a chance to mediate before setting a deadline for that. So I guess I'm kind of leaning towards Mr. Elliott's suggestion. And of course, you know, Ms. Olson, you're free to file that dispositive motion, if you don't need further discovery to do that at any time. So that's kind of up to you guys.
Understood.
Okay, so I'm gonna enter an order scheduling today that kind of reflects what we've discussed. I will get that out to the parties along with a cutoff date, or I'm sorry, a status conference date for our next meeting. I will provide in that order that the parties are to confer and attempt to agree on a mediator within the next 30 days. And if you're able to agree on it, to notify the court of your selection in writing. And if you're not able to agree, to notify the court of that as well. And then the court has a process as part of my typical pretrial order where parties are unable to agree on a mediator to select a mediator. And I will put that in the order as well. Either Mr. Elliott, either of you have any anything further that we need to address for purposes of the status conference today?
Just a comment, Your Honor. We have discussed the possible mediator. I think we'll be able to even agree upon that. So yes, you know, 30 days should be sufficient time to make a decision.
Okay, thank you. Mr. Arteaga or Ms. Olson, anything further that you would like to address for scheduling today?
No, Your Honor, I think we're all set here.
Agreed, Your Honor. Thank you.
Okay, again, I'll put this into a written order along with a notice of hearing for the next status conference, and all parties are free to disconnect. Thank you.
Thank you.
Thank you, Your Honor.